What you know, Alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Thursday, May 29th. Sorry I didn't get the recap in yesterday, but I knew today was a half day, so I thought I would just combine both. This testimony for me personally was a little bit hard to follow at times due to all of the math and the data that they were referring to. So I wanted to make sure I went back and rewatched a few things I wasn't clear about and just throw it all together and do a bigger one today. We had Judson Welcher from Aperture back on the stand. He was on direct exam at this point, very briefly before we went over into cross. The state asked about the paint on his arm while doing these tests, and the witness said the paint never went on the underside of his arm. And the SUV's damage is consistent with a collision with John, and it would account for him hitting his head on the ground very hard. As far as side swipes, what's being hit doesn't accelerate at the same speed of the object that hits it. There is no complete momentum transfer, and this leads to little damage being left on the car. It makes it hard for him to compute force with these types of collisions. When someone is hit by a side swipe, it doesn't show the broken bones that a direct hit would. And again, says steps taken by the person being hit would determine ultimately where they land. On cross, they go into the witness's conclusions that weren't based solely on the physical data, and witness statements were taken into consideration when the witness made decisions. Both the witness and the defense agree that the goal of scientific methodology is to reach their conclusion without bias. The witness is asked if one of the first questions he asked is, how did this happen? He says that's actually one of his last questions. When he starts, he has several hypotheses in mind, and as more information comes in, he may have even more hypotheses in mind when he is investigating a case. The defense points out that Aperture was hired by the Commonwealth 2.5 years after John's death, and they were paid over $44,000. The witness doesn't know any of the details about that. They bill for the time that's put in. But the defense brings up they bought a Lexus that was like Karen's for testing. The witness said it would be sold after trial, and if they take a loss on selling it, the Commonwealth would be billed for the rest. The defense points out the contract was amended to $325,000, which accounts for the price of that test Lexus, and says the total for 8 months of work was around $400,000. The witness doesn't recall the total, but he also doesn't have a reason to dispute that. He's asked about changing his report, and the witness said he hasn't submitted amended reports in this case, but he did submit an amended analysis. He's asked if he's aware of anything related to this trial before getting on the stand. He said he has gotten some random emails, one of those being from an internet troll, and he has also seen some news come up online in his feeds. The event data recorder does not record the location or the time of the trigger event. It records by seconds from the time the car is turned on to when it's turned off. They get into Newton's second law of motion, super technical, but Newton's second law of motion states the force acting on an object is equal to its mass multiplied by its acceleration. And the witness said his calculation shows that when John fell backwards, it created 7,200 pounds of force. They get into head injuries when talking about pedestrian strikes. And the witness says studies show of all the injuries, head injuries are the most common. The defense points out that the study the witness is referencing says 12% of these type injuries result in a fatality. And also that this study was done 45 years ago, and that studies that have been done more recently show that injuries to the lower extremities are more common. The defense says you don't have the information necessary to conclude with any certainty that Mr. O'Keefe, at the time of impact, had a level of his head in an upright position such that it hit the spoiler of the SUV. The witness says they do not have that level of certainty, but they have the height and the geometry which matches. When the witness went to 34 Fairview, he did not go into the yard. He stayed on the road because he didn't want to trespass. The defense asks about that raised berm, and the witness thinks it was around 4 inches. The defense points out he did not account for the berm, and it could have put John's body in a different position in relation to the SUV. The witness says he doesn't know if John was standing in the street or in the yard at the time of impact. He doesn't have enough information to determine the force that John would have had on his arms either. The defense wants him to do some mathing there on the stand to calculate the force John's arm would have been subjected to if it was stretched out for a 10-millisecond impact with the SUV. The witness came up with 2,188 pounds of force. The witness says in order to break the arm, the amount of force that would be needed would be at least 2,500 pounds, but it could be a little less. The defense asks about how much force would be necessary to break a hand and asks if 300 to 400 pounds sounds right. The witness says no, not for a distributed impact by a taillight. The defense tells the witness that he doesn't know precisely which part of Karen's Lexus hit John. The witness said his opinion is it was the taillight area. He concludes that with considering pieces of evidence that was found as well as DNA. The defense wanted that DNA comment stricken from the record, but the judge said no. They go back and forth about how much force is needed to break a bone. The defense says that Karen's SUV produced 7 times the force that would be needed to break a bone. The witness disagrees and said it would take around 7,000 pounds of force to break a bone for someone John's size. The defense asked what part of the SUV, if any, would give the kind of force needed to break a bone, and the witness said possibly the tailpipe. But both agree the autopsy report did not list any broken bones, and Welcher said he didn't see any x-rays of John's arms. He goes on to talk about an unrelated case where a victim was hit by a car that was going between 25 and 30 miles an hour, and the victim had cuts to his arm but no broken bones. As far as the paint test the witness did with the Lexus that was bought, he did this to show that the injuries on John's arm matched where the paint dispersed on his own arm when he did this test. The defense asked if he performed this test going at 20 miles an hour, and the witness is like, yeah, not going to do that to myself. So the defense wants to know why they didn't use a test dummy. The witness said they didn't have enough information for that type of testing. He can't say where John was standing at the time of the incident. So they move into the distance the witness said that Karen backed up during the event. The defense says the witness's chart shows the SUV switched degrees. And is it possible the SUV traveled in a forward direction for longer than 34 feet? The witness explains the trigger event only records 5 seconds before and after a trigger event occurs. And by that time it started recording, the car was already going around 13 miles an hour. But he is sure the SUV went forward for 34 feet and then backwards for 87 feet. The day before yesterday on direct, the witness said he thought the SUV tires were spinning. And he said the reason could be that the gas was pressed hard enough that it caused the wheels to spin. But he also says it could be because of that raised berm. If she hit that, it could cause the tires to spin. The witness is asked if the SUV would have ended up on the lawn if she reversed for 87 feet. The witness said it would depend on where the SUV was when it started backing up. They go back and forth for quite a while about these injuries on John's arm. The defense wants to know if, to the witness, the injuries that they show on screen on the upper arm are horizontal. And the witness says more or less they are. The defense says, but shouldn't the injuries be vertical according to your own test? The witness says no. He proceeds to talk the jury through how the injuries could have happened in a horizontal way, with that taillight being broken and then dragging across John's arm. The defense says under the witness's theory, John's arm and Karen's SUV would need to come into contact for a period of time, but wants to know how long of a period of time. The witness does not have enough information to determine that, but the laws of physics require they would have been in contact for a certain period of time. The witness said he assumed John's arm was stretched out to some degree, And the defense asked if that is an example of confirmation bias and if the witness considered any other arm orientations. The witness said he did consider that, but he did not put that in his report. He then says, I didn't come in here to tell these people what didn't happen. The defense asked the witness if his conclusions includes any confirmation bias, and he says no. The defense wants proof that the witness considered different hypotheses before coming to his conclusion. And the witness said he did a whole bunch of tests on the vehicle. And he's asked, where in your report is that? He points to different pages in his report and says he did 3 separate tests. And he tells the defense in his presentation where these slides can be found, where he did test other hypotheses. The defense says one of your hypotheses was that could the taillight break after coming in contact with John's car? And he asked if the ring camera at John's house was part of the laser scan process when they went to his residence to investigate when Karen backed up and hit John's car. The witness said that the videos were not used during the laser scan. They took the scans and then later combined the video with those scans together. The defense asks if the ring camera was utilized as part of the laser scan process. The witness said no. The camera and laser scans are not used with each other. The ring camera is used in the photogrammetry process. The defense asked about the glass that was found on the SUV bumper. The witness said he did not test where that glass came from. He does know it was found at the scene, but he cannot say if the glass taken from the SUV came from the glass that was found at 34 Fairview. The defense asked what was the purpose to use the video, and the witness said to establish dimensions to overlay things like tracks in the snow, and also to look at the damage to both vehicles at John's house. The defense says this was a basis to establish dimensions on the other work and analysis done at John's place, and the witness says correct. The defense says that the ring camera that was at John's house when Aperture did the work on October 2nd of last year was a different camera than the one that was mounted on January 29th. The witness was aware of this when he did his analysis. He did document the differences. However, he did not measure any differences of the placement of the old camera versus the new. They used the current ring camera with the old, and with the laser scans, they were able to map the points on scene. The defense stops him and asks, did you measure the difference? The witness says no, the new camera was angled slightly to the right. The defense asks, how would you know that if you weren't retained on January 29th? The witness said the new camera was slightly to the right. The defense says that is an eyeball thing, not an actual measurement. A millimeter turn of that camera can make a significant change. Did you measure if the newer camera was installed to the left, to the right, to the top, or the bottom, relative to the camera that was mounted on January 29th? No. The defense says that cameras can have different levels of distortion, and you don't know that sitting here today. The witness said their errors would have been too high if that were the case, and so because their errors were within acceptable limits, that gave him enough to get an accurate measurement. The defense says that the witness is speculating, but the witness says it's not. When they get images from both cameras and overlay data from the old camera images to the new camera images, if the distortion is too great, they would have had too many errors in their report. And he said that is why he showed their error range in earlier testimony. The defense asks about the cameras being different models, and the witness says if you have video from both and you have a laser 3D scan of the scene, you can go in and do what they call reverse camera analysis, which tells you real-world dimensions that you can go in and correct all that. They get really technical with light ray geometry and stuff that's just way over my head. But the defense really is just focusing on the fact that there are two cameras, one that was there on the date of the incident and the new one that was there when the witness came to do his work. The defense says almost all the work Aperture did at the residence came from that camera, the new one. The witness said, yes, it started there. The defense says if the starting point is wrong, everything else is potentially wrong. And the witness says potentially. The defense talks about swiveling mechanisms that users can adjust on the camera to adjust the view. And did the camera on January 29th have a swivel? The witness doesn't know for sure, but the style camera did have adjustability, including the angle that the user could adjust. The defense talks about lining up the Lexus with John's car and says you took 3D images of the cars to see if they would align sufficiently so the Lexus could hit John's car to see if the taillight could be broken. The witness said that was part of their testing, but there was more they did. They pull up a slide showing different views of the contact point between Karen and John's cars based on the images that the witness produced as part of his conclusion. The witness said what they're showing here is the angle of contact, but because it's a 2D image, you are losing perspective. They were just trying to show a lot of different angles to show the degree of closeness or the lack thereof. Defense says you said those 2 to 3 millimeters of overlap was insufficient to cause the taillight of the Lexus to contact the rear of John's car. The defense tells him to look at what he sees and asks if it's showing contact between the two vehicles. If you're listening to this and not watching on YouTube, the visual that they are referring to, if you look at it with an untrained eye, like most of us, I assume, are, it looks like they're making direct contact. But the witness says absolutely not. You're seeing a portion of the vehicle that's behind the area. Keep in mind, the Lexus is angled off to the left. So what you see here is in front of where the taillight is. And this is why they showed this from different angles. He said in the computer, they overlaid them and then looked at the measurements where they had the 3D measurements, and he says it doesn't hit. The defense asked, where did you show this in your slide? The witness said it showed a contact here, but not here. And all of the next slides in this presentation is where your answer is. The defense asks again if the witness is saying the photo up on screen now shows no contact between the two vehicles, but the witness says the upper taillight is what he's talking about to be clear and does acknowledge the lower taillight is much closer to making contact. The defense says it's not only much closer, it's in contact, isn't it? The witness says it's close, maybe within an inch or so difference from the rear of the car. The defense shows another photo and says, so you're saying this isn't contact? And the witness says it is not. The defense brings in an actual photo and points out the quarter panel taillight and asks if he sees a jutting out of the quarter panel taillight. The witness does point out these protrusions and say that they are more like little fins on the SUV. The defense goes back to that photo that the witness brought in and says that depiction does not show the jutting out. The witness disagrees and says it does. It's just more on the side and you can't see it in this image. But the defense asked, again, you can't see that jutting out here, and the witness agrees. The defense says you could have easily solved the issues you had with lining them up. The witness said, in his opinion, he took the best solution that he could. The defense says you had 3D images. You could have shown and measured 3D images to get almost the exact contact point if you had just used the 3D images available to you. The witness said that's exactly what we did. He references these technicalities and overlays that they used in their analysis. Defense, if you believe there was no contact or insufficient contact, you could have made a graph that shows that. They move on to the image of the bumper that the witness made and asked if it's grainy on the step pad of the bumper cover. The witness said they mapped the color over the 3D scans and they used two separate scanners. What we are seeing here is a laser scan, which is a 3D model. The defense asked if it's photoshopped. No. And the defense says you didn't do the work to produce that depiction. The witness said it is done for him. He is telling the engineers what to do. But I'm not punching the keys. I'm saying, do this, do that. The defense moves on to talk about hydraulics and asks, what type of hydraulic system does the SUV have? The witness said it's air-based. He can't recall the name of it, but he knows generally how it works. He knows that you can adjust for roadway height and things like that. The defense asked if he knows the height tolerance. The witness said maybe 1.25 inches. He measured it, but does not recall off the top of his head. And the defense asked, would it surprise you that it's 5 inches? The witness said he would be surprised, but he would need to check. The defense says, let's assume the manual and other information says it's 5 inches and it can be raised 3 inches high and lowered 2 inches, which is the basis for the 5 inches. What was the suspension height of the SUV you used for your accident reconstruction analysis outside 34 Fairview between 12 and 1 a.m. on January 29th to determine if it was possible for the spoiler to make contact with the eye of John O'Keefe? The witness said they matched from when the SUV was tested at the Canton Police Department on February 1st. The defense asked, well, what match did you make? The witness said they aligned the sheet metal below the taillight and adjusted the height of the Lexus to match that. The defense asked if he documented what level the Lexus was at any time when they were testing the suspension, and the witness says yes. He flips through his papers, he tells a slide, and they put it up. He points out that they matched from photos that were taken at the police department. Defense says, I asked, when did you document the suspension? Was it 0? Was it +3 or -2? Where did you document that? And the witness says, right here. The defense asks, what are the numbers of the documentation of that? The witness says, we were matching photos. I don't care what the suspension numbers are, as long as the height matches. The defense asks, what was the suspension height at 5:07 a.m. on January 29th when the SUV and John's car made contact? The witness said that they assumed it was the same as when the car was at the police department. Defense, you assumed, but there was no measurement or note saying we're doing the sensitive measurement to see if the Lexus made contact with John's car. There's no documentation. The witness said they took the closest in time to the incident, and that was when the SUV came into the Canton Police Department. The defense points out that the car's suspension is automatic. When you go above 20 miles an hour, it comes up, and when you turn it off, it goes down so you can get out of the car easier. And it would have been improper to assume the suspension is the same between these locations. The witness said that was the extent of the information they had, and that was when the car was at the police department. But when it goes slow backing up, it wouldn't raise up, meaning at John's house because it was a slow speed. He said the static position would be the same. The defense says, but when moving from point A to point B, it changes. The witness said, you pointed out it goes back down, but when backing up, she's not going more than a couple of miles an hour, and it's not going to be any different than when it was parked at the Canton Police Department. Defense goes back to 34 Fairview and says, you don't know what the suspension height was on the night of the incident, and the witness says that's correct. Moving on to the trigger event information. The defense asks about Bosch crash data retrieval system. The witness and the defense go back and forth. The witness is saying that Bosch is not part of Lexus. You take Bosch's stuff and you plug that into the Lexus to get the data recorder information. They talk about the vehicle control history and how many times it's recorded an event in the time Karen owned the SUV. The witness uses his laptop and says there were 18 events recorded before January 29th. He did not look to see if any of those were collisions, but in his opinion, the only collision was on January 29th. The defense says there was a collision between Karen and John's car, and the witness agrees the cars touched. Defense, the collision at John's didn't record an event, and the witness said it was just too minor. Defense says you want this jury to conclude the glancing blow at 34 Fairview by the same 6,000-pound Lexus coming in contact with a mere 200-pound man didn't register. The witness said it didn't. What started the trigger event was when the accelerator went to 30%. It doesn't register collisions at all. The trigger event doesn't tell you when the collision occurred, and the defense says exactly my point. It doesn't tell you when a collision occurred. That was it for the defense. But on a redirect, the Commonwealth asked if the replacement camera at John's house, when they did their analysis, affected his conclusions. No. There's some really technical talk about force and things like that I'll spare you from. And then Brennan shows the SUV data slide and asks, does the shift direction from forward, then neutral and reverse, does that data suffer from confirmation bias? No. Does the vehicle speed ending at 23 miles per hour suffer from confirmation bias? No. The witness said these are direct recordings from the SUV. The defense gets back up and asked if the data shows collisions. No. As far as confirmation bias, you were asked about data by the Commonwealth. But confirmation bias is aimed at opinions and conclusions and alternative hypotheses. The witness says generally, yes. He started this case with the hypothesis that the Lexus did not contact John at all. He starts with a null hypothesis, and then he looks for evidence to prove or disprove. That was it for the defense. The Commonwealth plays a clip from an interview, April 10th, 2024. Karen is saying she asked herself, could she have hit John? She said she always has the music blasting. It was snowing. The wipers were on. Was he trying to get me as I was leaving? Did I hit him and didn't know it? Did I hit him in the knee? Was he drunk and did he pass out and asphyxiate or something like that? She then says when she hired her defense attorney, Yannetti, she asked him those questions and she says her attorney told her then she has some level of culpability. After that clip, the state rests, and that was it for the last day and a half. The judge dismissed the jury and said tomorrow would be a full day in court, and the defense will call their first witnesses. So, hope you guys have a good rest of your evening, and we will see you soon.